Hi, I'm David Cahn. I'm a partner at the Baltimore office of Whiteford, and I'm here to talk to you about the U.S. Corporate Transparency Act and what it means for your business. The U.S. Corporate Transparency Act is a law that requires most privately owned companies active in the country to report information about their beneficial owners to the Financial Crimes Enforcement Network, which is a bureau of the U.S. Department of Treasury. Reporting began January 1, 2024, and must be completed by January 1, 2025 for most entities. So what happens if I am the owner of a business or an executive of a business and I don't comply? Under the CTA, it's unlawful for any person to either willfully fail to report complete beneficial ownership information, or BOI, to FinCEN, to willfully fail to report updated BOI, or to willfully provide or attempt to provide false or fraudulent BOI. People who violate the CTA's reporting requirements shall be liable to the United States for a civil penalty of not more than $500 for each day that the violation continues or has not been remedied, and may be fined not more than $10,000, imprisoned for 2 years, or both. And the U.S. may hold responsible both the company that should have reported and its beneficial owners who knowingly fail to comply with the CTA. So, what entities are reporting companies who must comply? A reporting company is a legal entity that is created by filing a document with a Secretary of State or similar office in a U.S. state, or that is formed under the law of a foreign country and registered to do business in the U.S. by filing of a document with a Secretary of State or similar office in a U.S. state. The legal entities include corporations, limited partnerships, and limited liability companies. Sole proprietorships and partnerships that are not created through a filing with a Secretary of State, or in Maryland, that is the State Department of Assessments and Taxation is the comparable agency, are excluded from the reporting requirements. So, what must a reporting company disclose? Reporting companies must file a BOI report with FinCEN online, identifying each human who either owns 25% or more of an equity stake directly or indirectly, or exercises substantial control over the entity. People who exercise substantial control over a company include those who are a senior officer, have the power of appointment and removal of senior officers or a dominant majority of the board of directors, or have substantial influence over important matters of the company, such as major expenditures or investments, and the selection or termination of business lines or ventures. Exercising substantial control does not require ownership in an entity, but instead relates to authority and decision-making. So if your company has a silent partner who exercises major influence over decision-making for any reason, then that person also needs to be disclosed. And we can provide assistance in figuring out what individuals would be deemed to be beneficial owners under the law. It's not necessarily as simple as it seems if you have multiple power centers within your company. So what must be disclosed? Each reporting company must provide the following information for each beneficial owner: full legal name, birth date, residential address, and a unique identifying number from an image of an acceptable identification document, such as a passport or a state-issued driver's license. As to the reporting company itself, you need to report its full legal name, any trade or doing business as name, the street address of the principal place of business in the U.S., the state jurisdiction of formation or registration, and then its employer identification number, or if it doesn't have one, a similar identification number issued by a foreign country and which country issued it. The reporting deadlines for companies formed or registered prior to January 1, 2024, they will have until January 1, 2025 to report BOI. Companies formed or registered during 2024 must file their BOIR within 90 calendar days of formation. And any updates or corrections to beneficial ownership information previously filed must be submitted within 30 days of the change. The update and correction process, in particular updates, is going to be one that everyone will have to monitor, because once again, if it's not a simple company with just a couple of beneficial owners, then there may need to be reports of updated information quite frequently. So, do I really have to do this? Well, understandably, a lot of entrepreneurs and business owners are not happy with this requirement. And as a result, several legal challenges have been mounted against it. The most well-known is called National Small Business United, Inc. versus Janet Yellen as the Treasury Secretary. And on March 1, 2024, the U.S. District Court in Northern Alabama, hearing that case, entered judgment for the challengers on the basis that the CTA is unconstitutional because it cannot be justified as an exercise of Congress's powers as stated in the Constitution. And so the court enjoined FinCEN and Treasury from enforcing the CTA against members of National Small Business United, Inc., which is a trade group, as of the date of the ruling, March 1, 2024. The United States has appealed that ruling to the 11th Circuit Court of Appeals, and FinCEN's position is that each reporting company needs to file and could be a target of enforcement unless it was a member of the NSBU, the plaintiff, on March 1, 2024. Since then, constitutional challenges have been filed in U.S. district courts for Maine, Ohio, and Michigan. Additional courts may rule that it is unconstitutional, or they may not. If you're a beneficial owner of an entity that existed prior to January 1, 2024, and you don't file by the end of this year, you could be fined $500 for each day in 2025 and thereafter until you file. So, bottom line is that each company needs to make an informed decision as to whether they will file. There are various exemptions available, but mainly those are for companies that are already regulated by the Securities and Exchange Commission or other governmental entities. If you decide that you do not want to take a chance on being fined $500 per day, we can provide assistance in figuring out who your beneficial owners are, and then making sure that you assemble their information so that you can make the filing. We also can work with you to make sure that your governing documents, such as your LLC operating agreement, are amended to make it easy to get the necessary information in the future that you'll need to comply with the CTA. Finally, for new businesses that you're thinking about creating, we can strategize with you as to the best form of entity and structure in light of the CTA filing requirements. Thank you.